Good afternoon, everyone. My name is Michael Wilds. I'm an immigration lawyer. I'm actually a second generation immigration lawyer, and I hope this finds you well and safe. This is being taped in the middle of the pandemic, and again, these are extraordinary times. There are about 180 people assembled to listen to this, and I hope that you grab some value from it. Again, Michael Wilds. I am a managing partner of a firm called Wilds and Weinberg, located in 53rd and Madison, also in Englewood, New Jersey, where I have the privilege of being its mayor, in Aventura, in Florida, and also by appointment only in Los Angeles. When I say second generation, my father started our practice in 1960 before he and my mother, rest her soul, started me in 64. Dad was actually John Lennon's lawyer when the then president wanted to deport the famous Beatle. It makes for a good read and wonderful case. I'll talk about it later at the end. But again, a privilege to be holding my dad's briefcase and managing his practice after all these years. And there'll be yet another generation, as I have two other lawyers coming from me who both took my class. Actually, I met my wife in my dad's class at Cardozo Law School, so you can say that immigration is in our DNA. Today's subject is the overview of U.S. immigration law, what every lawyer should know about immigration. I hope that you'll find great value, as I have and my family as well. A couple of pages here just in our brochure. You'll see we've had some interesting clients and relationships through the years, and we're here for you. So what is immigration law? First, it's the system of laws passed by Congress and implemented by several federal agencies governing the movement of foreign nationals to the United States, their rights, their grounds of removal, and eligibility for status and work authorization. If you see the arrow in front of you on the slide, the job is to get people to be US citizens all the way on the right. They can come here on weekend visas like a B1, B2, which is for a visitor, an F1 as a student, and then sometimes we get them professional work visas. I like to talk about the acronym HELO, H-E-L-O, the H visa, the E visa, the L visa, the O visa. We're going to go into them today. But those visas will give you a long runway so that one day you may want to get LPR, lawful permanent resident status, a green card for somebody. And of course, once they have a green card, they're then eligible for citizenship 5 years later, or if they're married to a US citizen, 3 years. Our government looks only at two kinds of people, and there are generally only three ways of getting status in the United States. The two is you're either a non-immigrant. These are for people who intend to work, study, or visit, or you're an immigrant, somebody who would like to remain permanently in the United States. And generally, the hallmark ways of getting status have always been based on employment, based on investment, or based on relationships. Of course, there are other provocative ways through the status, but that's generally the way it is. I actually teach a business immigration law class at the Cardozo Law School. And that is the benefit of having all of this inventory of visas, and it's a new area of law and lots of room for wonderful lawyers to join. The non-immigrant visas that we're going to discuss here, the key categories are going to be the B1, B2 visitors for business or for pleasure, the E visas based on treaties of trade, F1 students, H1B specialty occupation workers, and L1 intercompany transfers. Whatever visa, understand fundamentally, these visas are issued domestically in the United States through Homeland Security or through foreign service officers at the US Department of State at US embassies. Once a person gets an approval domestically, they go to the American embassy, you get a stamped, a valid visa in your passport, and it allows you to come in for the validity of that time. It can only be used for admission and doesn't control the conditions of your stay. When you come into America, you have to make sure that you maintain your stay and so forth. You can, in certain circumstances, get a visa renewed or revoked if you step out of line. And the dependents for visas and spouses and unmarried children always work until the age of 21. A child is a defined term in the immigration law. Many spouses can be granted work authorization and so forth. But fundamentally, we just want you to understand there's a double check on admission. First, you have to get a petition approved domestically. Second, the State Department has to be willing to readmit you. The next slide talks about border entry. At the border, the US Department of Homeland Security will then admit the alien for the status that they've been granted. So they are carrying generally two documents. One is the petition approval. The other one is the visa that you got in your passport. And then you're given a more formal record. It's called the Form I-94, which is done online now. And it can be downloaded at the site that I sent in the presentation. And future extensions of stays or changes of status can be made from there domestically in the United States. A term of art that you have to get familiar with in our space is changing status versus adjustment of status. A person changes their status when they go from one status to another status. If they're going one temporary status to another temporary. If a foreign national who enters on a non-immigrant status wants to then apply for permanent residence, a green card as it would, then you're going to be adjusting status. Petitions generally are filed when you're changing status or adjusting status. It's a petition-driven system by employers, certain family members, or by yourself. There are a lot of times where a person can serve themselves through the system as well. By operation of law, there is a special rule when it comes to Canadians. Citizens of Canada can present themselves at the border with an appropriate documentation to request admission under various non-immigrant visa categories without first obtaining a visa stamp at the US Embassy or Consulate. The exception are the E1 and the E2. So that is basically, we have carve-outs, and this is all based on experience, and there are other Western Hemisphere-centric rules that we'll get into. But the bottom line is, accepted from most visas other than the E-visas are Canadians. So there's a little less drama for Canadians on needing to travel. You can see how there's a built-in prejudice when Mexican nationals are treated differently than Canadians, and it's something that has affected our practice. There's also the visa waiver program. We have about 37 or 38 countries, I think Poland came on recently, that allows country men and women from these 37 or 38 countries to come to America for 90 days, no questions asked. It's a ESTA. It's a visa waiver program that's onboarded through a computer system. Basically, you're waiving your right to a day in court. You can come up to 90 days, much like I can go to France, I can go to Belgium. We can have those nationals come to the United States, and you have a list of all those countries there. Effective January 12, 2009, you have to use this electronic system online before you come. You may not change your status from one status to another. During COVID, we've had scores of our clients having to apply for what's called satisfaction of departure, which is to get an emergency 30-day extension in the event of medical exigency and so forth. But the visa waiver program, be very careful. If you come in with a visa and they mistakenly enter you on a visa waiver program, you have to go back to the airport and make sure that you were admitted properly. So again, Canadians have one privilege. They don't need a visa endorsed in their passports, and any country, a man or woman from those particular countries on a visa waiver are treated very differently also, and they can't ask for work visas domestically. They have to then leave in order to get a better result. Moving to some of the business visas, I'm going to discuss the B1. The B1 talks about foreign nationals who are permitted to enter the United States, and B1 to conduct business. B2 is for pleasure. The B1 classification permits somebody to participate in meetings, conferences, other activities to facilitate the exchange of information. Be very careful that what you're doing is business and not employment. You're not allowed to receive salary on a US source for services rendered on this trip, and the US source may provide expense allowance or reimbursements for incidental expenses, but it can't be more than actual reasonable expense for travel, meals, lodging. And the maximum stay is for 6 months, but it begs the point, if you're here for 6 months, are you really working? And how can you be away from your business? It's not really a casual meeting as what was contemplated. The B1 permissible activities would be to negotiate contracts. Your client is going to open up a restaurant. There's a piece of litigation, independent research, taking purchase orders, consultation with business associates, participation in conferences or conventions or other professional commercial kind of activity. There's a hallmark case, the matter of Hira, that my father handled, where there was a dragnet of 12 business people that were arrested all at once. They were actually taking measurements of suits in hotels. And my father was able to successfully win, and this was a 1962 case before I even came on the picture, where my father proved that the purchases were just merely incidental to international trade and that the work was being done in Hong Kong. And to this day, that company advertises in the second and third page of the New York Times every day since 1962. It's like Mohan's suit. And that dragnet tried to protect American laborers when in truth it was just incidental to de minimis work being done in America, and it was a permissible B1 activity. The F1 student visa is the next hallmark visa. These are for students that coming in for a full course of study. After getting a degree, a person can get a 1-year OPT, optional practical training. And for each ascending degree, you get another OPT. So postgraduate employment, you have to be, you can get this practical training work authorization for a full year after you get a whole degree. The process is initiated by the DSO, the designated school official, and it's recommended within 90 days of completing your course. It's not tied to a particular employer, but to a field of study, and you must obtain the work authorization document from USCIS prior to the commencement of the employment. You can get 1-year OPT for each degree. So if you go for 2 masters, you're only getting 1 OPT. But if you go for a PhD, then you're in good shape. But the F1 visa is a wonderful way to come to the United States, but it's a weekend visa to apply for a green card while you're domestically, because each student has given an admonition to the authorities that they're going to depart the United States at the completion of their studies. And applying for a green card means that they can pick that up when you're traveling. So we do have students that apply for green cards, but we generally curtail their travels intermittently. There are also F1 STEM regulations for students that are holding degrees in science, technology, engineering, or math. They can extend their OPT by an additional 24 months. So they get 3 shots effectively at trying to do the H-1B visa, which we'll get into a little later. STEM fields include actuarial science, computer science, mathematics, and other technologies. The F1 must be currently participating in a 12-month period of OPT with a U.S. employer related to a STEM field. They must have at least a bachelor's, master's, or doctoral degree, and the student's employer must be registered with and participating in the E-Verify system. If the employer isn't, then the student cannot onboard. Now, this is something that will definitely put you to sleep, but it is a timing issue, and I need a whole class to explain it, but I'm going to attempt in broad strokes. So a student who graduates school and has their OPT, their optional practical training, will be given a work authorization card, which will have a certain expiration. If you want to onboard into the H-1B visa, which can only be applied 6 months before its eligibility, which is in April, for an October start date, that's when visas start. A student whose work authorization expires before or after the April date, it could be in jeopardy. So a student who holds OPT, which expires prior to April 1, is entitled to an automatic extension of status only and not work authorization until October 1st if an H-1B is filed and accepted with a request for a change of status from F1 to H-1B. Fundamentally, again, a student who holds OPT, which is valid until April 1st, is entitled to an automatic extension of status and work authorization through October 1 if an H-1B petition is filed and accepted with a request for a change of status from F1 to H-1B. This cap gap, that's the principle as to whether or not a student can make it to the other side, is something that they will have to consult with you or somebody in this DSO's office in order to see if they can actually onboard. But for each student that has a bachelor's degree, they're entitled to apply for an H-1. So if they're in America for a master's, they could have already applied, and we'll get into that in a few minutes. Actually, let's get into it now. The H-1B specialty occupation visa, basically it's professionals with a pulse. If you have a bachelor's degree and a pulse, you can apply for an H-1B visa. A U.S. bachelor's degree or the experiential equivalent of a degree, we allow it 3 years to every 1 year of school that you're missing. I had a notorious client who never stepped foot in college, but he had about 30 years of work experience, and we got them the equivalent. Once you have 12 years experience, you can get the equivalent of a bachelor's degree and then have somebody petition for them. The H-1B also is eligible for a master's degree or people who perform services in occupations requiring theoretical and practical application of a highly specialized knowledge. You can't sponsor somebody as a translator because you don't need a college degree to fundamentally know a certain language. The H-1Bs are petition driven. The U.S. employer must offer a prevailing wage. So understand the culture here. Foreign students who end up going into employers are being paid on their OPT a minimum wage, 15 bucks an hour. But when they're being sponsored for an H-1B, this is why a lot of employers don't want to do it. And only transfer H's, which allows for it, is because they don't want to pay prevailing wages. Also, the position must be directly related to a foreign national's field of study. And this is where we saw, particularly under the Trump administration, if you were an accountant and you had a license, you can do an H. If you're a lawyer, you're going to be petitioned as a lawyer, you can do an H. But if you have a degree in marketing, then the real question is, can it be sponsored someplace else? Again, they're cracking down on this, and you have to do a good intake when you take these matters in. But the H-1B visa, there's only 65,000 of them a year. There's an additional 20,000 for people with master's level education in the US. There are generally about 200,000 people that apply for it. And it's much like pregnancy. It's either yes or it's no, and you have to be transparent to your client. They will give you a roster of time to apply. If you're selected, then you have several months to make the application. The process is changing, and we're hoping that Congress will step up and do the right thing. The next visa is and one more point about the H-1B. There is a portability clause that's very handsome. It allows you to move the H-1 to a new employer. In fact, you can go on the payroll of the employer once immigration gets the new application. You don't have to wait for the approval to come in. So it is a wonderful visa, and it allows you to apply for a green card. The next visa are for Canadians and Mexicans. It's the trade NAFTA visas. Was in jeopardy practically with the president that just left office, President Trump, but seems to be on safe ground now. It's limited to specific occupations on the NAFTA treaty list. Educational credentials of the applicant must match the requirement for occupation. The TN visa initial application admission is for 3 years. You're not allowed to have dual intent, so changing to an H-1 is smart if you want to apply for a green card, because an H is allowed to apply for a green card. If you stay on a TN too long, ultimately the government could deny it. There's no statutory limitation on how many times you can have it, but you can be denied for having an immigrant intent if you stay on it too long. There's also an E3 for Australian citizens. So when clients come into our office, if they're Canadian, I'm thinking TN, is their job on the list? And by the way TNs are affected very easily for Canadians at airports, but Mexicans have to go into embassies. If I have a client that's an Australian, there's the E3 visa, which is kind of a carve out H-1B for Australians. The application must be submitted to the US consulate abroad or domestically to USCIS. Again, a specialty occupation requiring at least a bachelor's degree. It's granted generally for the same period of time, and there's no dual intent. You have to make sure that you change to an H-1, and there's no portability clause. If you get a new job, you have to affect a new H-1B. Again, there's no statutory limitations on how many times it could be renewed, but if you have it too long, it could be a problem. Now we have the J visas. The J visas are exchange visas. We know them as au pairs in America in the hospitality space. These are young people that are working in hotels. They're either trainees or interns. So the J1 trainee is valid to 18 months. You must have obtained a foreign degree in 1 year related work experience or 5 years of related work experience. Or the J1 intern, which is valid up to 1 year only. You must have obtained a foreign degree within the last 12 months. These are, again, like a stage and apprenticeship. The rules of the sponsor apply in addition to USCIS. You can get health insurance through them, and it's based on reciprocity. There are cross-cultural activities and orientations. You have to be careful because some of them may have a 2-year foreign residency requirement where they must go home to their home country actually for 2 years on completion of the program to obtain a waiver before they can get an H or an L or some other more sophisticated visa. This is largely available for medical students, summer work, and au pairs, but be very careful if you get it, it may come with a consequence. The other visa is the L visa. Again, the acronym HELO. Those are the visas that we spend our time toiling as immigration lawyers. The L are for intercompany transfer. You work in a company abroad that has affiliates or subsidiaries in the US, you can come in from a parent, a subsidiary, an affiliate branch, or joint venture. At least one office must be in the US and one outside. You must be on the payroll for 1 year within the last 3 years preceding your transfer to the United States. And you have to move either as an executive or manager, that's the L1A, or somebody with some kind of proprietary or specialized knowledge, that's an L1B. The L1A is good for 7 years, and the L1B is good for 5 years. Both the H and the L allow for a dual intent where you could apply for a green card, and it's a smart position to position your client in that station for that reason. Also here, the L2, the spouse, is permitted to work, where the H4 for the H is not permitted to work. So spouses in dependent L2 status may file applications for work authorization, and it's a much stronger visa, but you can't get it unless you worked abroad for a year. And a lot of times we're advising our clients to actually do all that kind of fancy maneuvering. That is, go abroad, work for a year, come back. But if the company doesn't have a majestic spread of people and employees, and here the government will look, you're a manager, good. How many professionals are you managing? We want to see all of the resumes in the group, and we want to make sure the kind of work that you're doing can't be done other than in America. With all the portability and that we're doing with Zoom and everything, immigration has opined significantly and has been flexible for the most part also when it comes to these jobs, but you have to be careful to show eligibility. Moving now to the e-visas, these are treaty trader E1 or investor E2. So if a client walks into your office and they come from a country where we have treaty trades, that's E1, or E2, where they're making investments, that's another robust way of getting status. The applicant must be a national of a treaty country. Some countries have E1s and no E2s. Some countries get both. The trading firm for which the applicant is coming from must have the nationality of the treaty country. It must be substantial in the sense that there is large trade. It must be principally between the United States and the treaty country, which is defined to mean more than 50% of the international trade involved must be between the US and the country of your nationality. The trade means the international exchange of goods, services, technology. So if you're in the diamond business and you're trading and you're from Israel, you can come in. If you're part of El Al Airlines and it's owned and it's run by the Israeli government and you're trading people, you can do E1s. Trade is trade, and it's there, and it's clear for us to see it. The applicant must be employed in a supervisory or executive capacity or possess highly specialized skills that ordinary citizens normally wouldn't have. The E2 is very different, and I point to my nose when I teach this to my students. The government will want to see where you got your cheese if you opened the pasta place, if you see a red and white tablecloth, if there's a cash register in a water cooler. Here, the investor could either be a real or a corporate person, must be a national of a treaty country. Again, we must have treaties. If you're from Italy and you're opening up a pizzeria, the investment must be substantial. It must be sufficient to ensure the successful operation. So the government wants to see everything in operation before they give you the visa. It must be real operating enterprise. Speculative or idle investments don't qualify. Also, real estate doesn't qualify unless you have a huge inventory because it's passive. The investment may not be marginal, and it must generate significantly more income than to produce just a living for the investor. The investor must have control of the funds in the investment, and it must be coming to America to direct the enterprise. So the question asked of me is, how do I get in here to fully operate and do a restaurant so I can get my e-visa? And generally, you have to look for an American partner or be selective so that you can use your B1 visa properly when you come in to set up the business, but that you're not accused of actually working for yourself. So you have to be very thoughtful on how you handle these things. O1 visa. Now we have a whole practice group in the O visa group. These are really for rock stars in their space. The O visas that we have done in recent years, if you go online, are for the likes of Boy George, the singer, John George, the chef, Pele, the soccer icon, lots of models, Giselle Bundchen for that matter, and a lot of other extraordinary scholars. The late Rabbi, Lord Rabbi Jonathan Sachs was a dear client and a friend. People who are extraordinary in their space. We've done them for tattoo artists, to people who are exceptional in the arts, business, entertainment, and athletics. It's available to aliens of extraordinary ability in the arts, science, business, education, or athletics who have achieved national or international acclaim. Individually, they last up to 3 years, and they can be extended indefinitely in increments of 1 year. It requires an advisory opinion from a peer group describing the alien's ability and the achievements in the field of endeavor, and we know it when we see it. You have to be very careful. We've been greatly successful in getting O visas for people coming right out of school if they have traction in their rearview mirror, having worked someplace, and they're just coming to America to learn something. We did a cosmetologist once for Lionel Richie, and we made the case that she was coming to do something for de minimis education, to learn the science of a certain color and use, but she had a long runway of experience in her space beforehand. Again, the O visa is being used, and it is a means-based, skill-based kind of experience. And we have been able to craft with agents an independent way where a person can be their own gentleman or their own gentle lady to actually develop their own stride in America, where you're not being sponsored for somebody who eventually will terminate you and you're being held vulnerable by an agent in your space that will make too much money. So there are ways to kind of craft your own independent narrative in this visa, and we've been highly successful at assessing in our intake consultations whether or not the person is close to it, and then coaching people to get to it, and then resolving a path to a green card for those that would like to achieve it. The next visa briefly is the R1 visa. These are religious work visas sponsored by a tax-exempt IRS 501c3. The individual must have been a member of the denomination for past 2 years. It must be work in a religious vocation, religious profession, or tradition. It can be part-time. The minimum is 20 hours a week, but it won't happen until there's a site visit by a government agent to make sure that there is a need for a new person and that you have the talent. So it comes up to 5 years, and you get the visa in 2.5-year increments. After 2 years, there's a direct path for a green card for religious workers. So I like this visa because the threshold requires you to have been a member of the denomination for 2 years, and generally religious studies are very robust. We've done them for all faiths, all denominations as well. The next slide gets into the meat and potatoes of our practice, and that is, if you violate your status, you can tell by the bad face and the stop sign, remaining in America beyond your expiration of your authorized period of stay affects your non-immigrant and renders you unlawfully present in the United States. An individual who's overstayed must apply for a new visa at a U.S. foreign consulate, in some circumstances only in the country of your nationality. Other ramifications of an unlawful presence render certain long-term overstays inadmissible to America. So if you overstay for 180 days, 6 months, you're stepping out of America after that means that you're facing a 3-year bar. This was set up by President Clinton to make himself look awfully Republican in 1996, and he got reelected. And unfortunately, when he left office in 2000, the law stayed on the books because of Congress's reticence to change the law all these years since 9/11. And right now, there's also the 10-year bar. So it's called the 3 and the 10-year bar. If you overstay a visa for 6 months, you're out for 3 years. If you overstay a visa for a year, 365 days or more, you're facing a 10-year bar. So be very careful. In some cases where the applicant has failed to maintain their status without work authorization, they may nevertheless obtain an immigrant visa through processing at an American consulate. So don't do this on your own, and check it out, because there are waivers and exceptions to this governing rule. But understand fundamentally, there is a presumption of immigrant intent when anybody is coming to the United States. By law, all persons applying for a visa or admission are presumed to have the intention of residing in America. The presumption must be overcome in order to be admitted and get the visa. You have to do this at the embassy. Even though you got an approval at Homeland Security domestically in America, when you show up at the embassy, you have to assume that. And then when you use the visa to come back to America, you're going to also have it. And that's why a lot of these agents stand there, all brazen and everything, because you have to have, it's a humbling experience. The burden is on you to prove it. One way of doing this is by showing evidence of an unrelinquished foreign domicile. I left my husband at home. I have a bank account at home. The same presumption applies when applying for extensions of non-immigrant visas or visas reissuing at borders. So understand an H and an L, as I said, is allowed to apply for a green card. So you have no worries if they find this information. But if you're a foreign student and you walk in with a wedding ring and they start asking you where you're getting married, and I see here that you registered on, they can look at your iPhone. I see you registered at Tiffany's, Bed Bath and Beyond. It looks like you're not doing portable stuff. What are your plans? So the fact is you can marry a foreign national, but if you don't have a good narrative to explain that when you finish your studies, your plans are to leave, the government can then presumptively say that you have an immigrant intent. So you have to be able to justify your stay and so forth. Now, getting green cards from the visas that I explained really depend on, based on the kinds of processes that you're doing. There are family and employment-based preferences based on the petition of specific close relatives or citizens or green card holders, or upon the petition of a sponsoring employer or prospective employer based on investments that you've made or the diversity lottery program. The effect of all this is when clients come to see us, and we're just talking about temporary visas, we're also trying to position you into a good station visa-wise so you can have a dual intent and apply for a green card. Or sometimes we'll say to a student, clip your wings, let's apply for the green card while you're in school. You have lots of OPTs for the different degrees that you're going. Let's get it done and dusted. Or let's buy the green card through the EB-5 program so you don't have to worry about finding the right husband, wife, or employer. Such statuses can be sought either through the immigrant visa application before a U.S. consular abroad, or in certain circumstances, adjusting your status, not changing, you're adjusting from a temporary to a permanent status. So the fundamental question, somebody sponsors me, do I have to stay with them? No. The 13th Amendment abolished slavery. A permanent resident who has obtained their green card based on an offer of employment has made a representation that they intend to be so employed. It doesn't preclude the possibility that at some time subsequent to the issuance of the green card, circumstances may change so that you're no longer appropriate for you to remain with the employer. You can be fired, you can quit, but it has to be done in a way to show that you were in good faith, intending at all times upon entry that the alien was entitled to keep such permanent resident status. There's no set employment period required, but needless to say, the longer one remains in employment with the sponsor, the less likely that immigration will challenge the good faith of the parties. And they get multiple bites at the apple. They get to see you when it comes to citizenship and to evaluate the propriety of either if you're there for 3 years, if your marriage was real, even if you got divorced, or if you got a green card through a way that now may be changing. The employment-sponsored preferences to getting green cards is the EB-1, but I'm not going to be technical. It's for people who are extraordinary in the arts, science, and education, business, or athletics, outstanding professors, multinational managers, those L equivalents, the professionals of exceptional ability, and individuals with advanced degrees, or people doing things in our national interest. There are also pre-certified shortage areas, nurses, physical therapists. And for those R1s, those religious workers, or the fourth preference when it comes to victims of spousal abuse or certain UN employees, or an investor. You can literally buy a green card. It's called the EB-5 program. My dad testified in support of it, in 1990. And knock wood, we've had great success with this program. You can get it either by investing $1.8 million and putting 10 people to work, 900 grand in a targeted employment area with 10 people to work, or create employment in one of those regional centers that most of our clients do, where there's, again, 10 people for every one person that's investing in a green card. But here you're going to get a conditional green card. And it's very important for you to understand, again, the difference in this. The immigrant investor visa, again, has 3 ways of getting it. The investment must be at risk, and the applicant must establish that the capital was obtained by lawful means. It's most of our job to show the source of the funds and the eligibility of the regional center if you're going to do it. Our favorite was the Barclays Center in Brooklyn, where everybody in the world saw the governor of New York wanted it, the mayor of New York wanted it. 10 guys selling beer at the Barclays Center. Somebody in China gets a green card. 10 guys selling popcorn in the Barclays Center. Somebody in Germany gets a green card. It's bridge loan financing, and it's a very big visual. And these regional centers often are robust enough, but there's a lot of fraud, so be very careful. I don't trust most of them. We tell our clients out of the 875, there are probably about 30 that we are comfortable with, but we don't have the right to dispense financial counsel. We're not licensed to do that, so we have to partner up with important groups, or the client has to do it on their own. The special immigrant religious worker has its own green card that could be filed for, again, after 2 years, you get the R1 visa in 2.5-year increments and has its own path for permanent residence. And then the perm, a perm is a haircut to many, but in our vernacular, it's the labor certification. It's the old conventional way of running ads in the newspaper, a little bit of a waltz, if you would, that the Department of Labor has a complex process by a certifying job that may be offered to a foreign worker because the employer has tested the labor market and that there are no Americans that are suitably qualified. This is called the Permanent Alien Labor Certification, or PERM. It's an acronym for this filing system. You have to run ads in the newspaper and go through this protocol. It's something that our office has great proficiency with, and it's a wonderful way. The law, very simply, in the world of H's, if you have an H1 for a facility. So the important thing at all times is to understand the minute a client comes to you, you're about to apply for a visa. What are the access points for green cards? When do you need to file them so that your client will never be in jeopardy without a runway ahead of them? There are also family-sponsored preferences. And again, I teach a class in business immigration law, but the family basis has all sorts of immediate relatives of US citizens that can allow you access. It was unfortunate that our former president tried to scare everybody into chain migration. I actually represented Mrs. Trump, her parents, and her sister in helping them achieve a green card and citizenship. And it's not the truth. And you can see in the world of YouTube the hearings that I had on this. And this is part of one of America's strongest bedrock traditions, that families come here, employers come here, and then they sponsor people who then sponsor other people. They'll work harder, they'll love harder. And it's a wonderful way when we're able to pivot in the middle of a sophisticated business person's case and have a family basis to sponsor where there are no favors asked by companies and so forth. Keep in mind that there are also two spaces or stations in life. And by the way, you should just read up. I'm a very proud Democrat on how difficult it was for me to represent the First Lady to a president that was trying to set our nation back on immigration control. So again, a lovely family from Slovenia wasn't going to stop me on principle, and the country needed to have a good hearing on what our law was and should be. There is something called the conditional green card. There are two stations where you'll only get a conditional green card. One is in the EB5 space, where you're making that investment of $900,000 into a regional center. Or if you're doing a marriage case, if you're marrying an American citizen and your marriage is less than 2 years, the government will responsibly ask you during the 90-day period preceding the second anniversary of your grant of conditional green card to file a petition to remove the conditions to the green card. Failure to do so will result in the termination of the green card. Here, the government wants to know, if you married somebody, we know you entered into the marriage for a good reason. Now we want to know that you're continuing. So if you had a child, if everything is good, that's wonderful. What if things are bad? Well, the government doesn't have you stay in a bad marriage for good reason. They just may want to see the narrative for the divorce to make sure that it's clear and consistent. And it's important in the regional center space to make sure if the project didn't get built, can they pivot the money, the regional center, to another project, which is why you want to be thoughtful where you put your money in those projects. There's also a diversity lottery program. We have a list of countries that can participate, and they're given 50,000 green cards a year. And you have to at least show that you have a high school equivalency. A lot of clients secure that, and it's by happenstance. Another area of our law, for those of you that are interested, is employer compliance and sanctions. The Form I-9 has become a very big issue, requiring ongoing obligations to monitor and control employees. Within 3 days of hire, you need to show that the person is who they are and that you've authenticated an I-9. And we do a lot of prophylactic audits of I-9s to make sure that they're in order. There are companies that hire us every year to certify and to train them as needed. ICE does I-9 audits, issued notices of inspections. There was one year that did 652 businesses nationwide. And again, they're entitled to the I-9s, all supporting documentation in the current payroll. So is your company onboarding people properly? It's not just getting the visa, but making sure you revalidate it when they need to be extended. And are you keeping the records properly? And this is another way that companies are then visited by the federal government and SoFi. A way to supplant that is to join the E-Verify system. It's basically known formally as the basic pilot. Most federal government contractors are required to do this. It's currently voluntary, and there are major problems, unfortunately, with it. But you also have to be careful in this balance to make sure that the government in 1986 under Reagan shifted the responsibility to employers to police immigration. You have to make sure at the same token that when you're doing this, that you don't discriminate. You don't ask people for the wrong information. They set up the Office of Special Counsel for employees to be able to call and rat employers out if there's unfair immigration related employment. You can't say just to Spanish people, show me your documents, or do you have a passport? Are you authorized to work in the United States? And then you have to take what's given, and you have to make sure that you have practices that are anti-discriminatory proof. Grounds of removal, very quickly. Wow, you can be deported basically for anything extraordinary in the world of space, of criminal space, that is. If you're convicted of certain criminal offenses, sometimes even relatively minor ones could be deemed to be crimes involving moral turpitude. There are no statutes of limitation on deportations deemed to be a civil remedy. So any kind of crime, which is why we always want people to get a visa, get it extended, go to green card, get citizenship, close it. Because if you get convicted of a crime, you could still face banishment from the United States. And a lot of our clients could have avoided that. In some of our extraordinary cases, we found clients who were actually citizens. They were in removal proceedings, but they had derivatively secured citizenship unbeknownst to themselves and the federal government. So even long-term legal residents with family and other substantial equities in America may have no relief from deportation if they are convicted of certain crimes. Be very careful. And we also deal handsomely in trying to protect a person's green card. With COVID the way it is, and hopefully was by the time you watch this tape, you could lose your green card by being out for a full year by operation of law. You can do what's called a reentry permit that procedurally protects you and allows you to be out for 2 years. And that's another document and another way of preserving somebody's residence. Again, physical presence requirements for citizenship eligibility aside, you want to make sure that the two balls you're bouncing, one is to keep the green card alive, and the other one eventually to get citizenship, that you don't screw up both, because you could lose both if you don't protect it. Getting a reentry permit allows you to be out for 2 years, no questions asked. The golden grail finally is to get citizenship. You can get that by birth in the United States. All persons born in America are citizens. You can acquire it at birth. You can derive it through the naturalization of your parents or apply for it through your own naturalization. You want to become a citizen because not only are you protected from removal, it gives you the right to vote, the right to participate in federal programs, to have a US passport, and there's certain jobs that will not give it to you unless you have that. I'm a big fan of getting citizenship. And there's certain countries that you cannot get citizenship. All these years, and it's public record, we still represent Yoko Ono. Every 10 years, we have to extend a green card. If she became a citizen in the United States, she would lose face and her citizenship in Japan, and she hailed from a very distinguished family. You have to make sure that you go to the higher status, and ethically, I think it's important to have these conversations with clients so that nothing in their rearview mirrors would cause them harm. So the intersection of what every lawyer should know about immigration and what every lawyer will eventually come into knowing immigration is very important. And I think I'm going to speak to it very briefly. First, in the world of estate planning, for some of our wealthier clients who come to us through their home offices or their tax lawyers, you have to be very careful when it comes to marital deduction, the loss of renunciation of citizenship or expatriation. the mark-to-market tax, transfer tax, and withholding of non-grantor trust distributions. When it comes to trust and income taxation, I always tell people to go to their specialist or make a referral. And I'm happy to take your cards, as it were, find me if you don't mind, and make referrals to you. Because deciding who's a resident for tax purposes, dealing with double taxation, Social Security, and renunciation of these income taxation rules are very, very important and delicate. And a lot of people are fearful about getting citizenship when they're paying the same tax. And unless they have literally hundreds of millions of dollars in offshore, there's no reason for them not to become citizens. And then it's a mad rush when they pass to get a deduction for them. The US immigration law separates individuals in three categories generally for taxation purposes: immigrants, non-immigrants, and undocumented foreign nationals. But the US tax code only recognizes two classes of immigrants. That's resident and non-resident. So if I have a green card holder and then they fill out a non-resident tax return when they leave because they spend more days that year outside, they've effectively shot themselves in the foot on their green card. Very important that they're on one page, as it were. The main distinction is fundamentally that resident aliens are taxed in the same manner as US citizens on their worldwide income, and non-resident aliens are taxed according to the special rules contained in the Internal Revenue Code. A major distinguishing feature of this taxation distinction concerns the source of income. A non-resident alien, with certain narrow exceptions, is subject to federal income tax only on income which is derived from sources within the United States and or income that is effectively connected to a US trade or business. But again, please make sure that you speak to both a competent tax and immigration lawyer at the same time. In the world of labor law, the labor certification that I spoke about, the conventional perm case, employer sanctions. We have a lot of calls all the time about these Social Security no match letters that companies are now on actual notice that they may have some immigration visits or violations, and the anti-discrimination provisions of dealing with labor matters. We're generally referring labor lawyers, and labor lawyers are referring us, particularly in the domestic setting. There are 3 points of exposure if you have an illegal housekeeper in your home. And one of those is the labor, wages and hours. Are you keeping timesheets? I tell clients all the time, the immigration authorities may not show up to your home. They will to your business. But you have timesheets? Have you been respecting the wages and hours? Do you have proof to protect yourself? And I make referrals often because the labor and the tax implications of domestics is something that's very significant. And just a word on domestic, when you start moving somebody interstate, they're paying for plane tickets and taking them for your favorite Passover holiday to Florida, you're now smuggling, harboring, facilitating, transporting. You're doing a lot more things than you are just by having somebody work illegally in your household, and you have to be very careful. In the world of corporate and commercial law, you don't want to have a merger or an acquisition or a purchase or a sale of a business unless you've looked at their I-9s. Business formation in the right constellation of visas can give you an L1 or a proper E or E2. Entrepreneurs and investors and intercompany transfers play a significant role in our discussions. In the space of family law, prenuptial agreements, separation and divorce agreements are critical. Somebody who's removing the conditions for a marriage case is now divorced. You don't want to have an abandonment as the basis of a divorce, because the government could draw the narrative that you were never there and you only married them for a green card. A prenuptial agreement is a wonderful agreement to show that somebody went into it, and we often give it to the authorities to show that they went in thoughtfully. The affidavits of support have great family consequence, and adoptions and other issues come up all the time. In the world of criminal law, as I discussed briefly before, it's imperative that judges, prosecutors, defenders, and non-citizens in criminal proceedings are knowledgeable of the immigration consequences of criminal convictions. I'm a former special assistant United States attorney. I had general exposure when I graduated law school to different areas of law. You want to understand, if your client or the circumstance has somebody with an accent, that there could be a consequence beyond what they're asking you when it comes to immigration. Non-citizens must be afforded the opportunity to consult with legal counsel pending a final criminal conviction. If not, then it could be a major, major problem. And that is ultimately what we see in the intersection of these areas of law. I'm going to entertain some questions now, if there's any questions, and I'm happy to, if you put them in the chat box. I left about 10 minutes for some questions and answers as well. But before I do that, I do want to urge any of you interested in this field to understand what a real honor it is to sit every day and toil in an area of the newest entrepreneurs and risk takers in America. It was a bumpy ride for us in the last 4 years with President Trump. But America's doors have been open. I wrote a book 2 years ago called Safe Haven in America, Battles to Open the Golden Door. We want the new inventions to be in America. We want families to be reunified and to find safety in America. And fundamentally, we have to remind ourselves that America was built on the backs of immigrants, and that that door needs to be open on a hinge so we can shut it against those that would cause us harm, and opened into the greatest risk takers and entrepreneurs and inventions. And I see it all day long. We see families in the Filipino community that are taking care of other people's children for decades, and their own children are being raised by the grandparents left back in the Philippines. We see this in all walks of life, and we have had the years. And I can tell you that this is a wonderful, robust area of law if you're considering things are light or you're looking to get into the people's space, because this is a very people-friendly area of law. If you like litigation, we have a robust court system. My son is working right now in the Miami courts supporting immigration judges, and thank God there'll be a third generation of the practice, and he's planning on joining us. My other daughter is at Milbank doing estate work. I'm proud of them, but they both went into the law, not on their father's example, but their grandfather's example. And there's a photo in the last page here of a book that their Zadie, their grandfather, wrote called John Lennon versus the USA. In the 1970s, a president then, imagine this, wanted to use immigration to deport a famous Beatle. The 26th Amendment to the Constitution was completed, and they reduced the age from 21 to 18 for teenagers now to vote. And it was penned in letters from Strom Thurmond, the senator at the time, that a lot of headaches could be avoided if we got John Lennon deported for a criminal conviction that he had. And they tried to use his criminal conviction to then have him removed from the United States for political reason. My father ended up, who had no idea who the hell John Lennon was, and that's why it's a much better read than my book, because it's really robust. And he's not just one of the most important immigration lawyers of our time, but the case itself ended up being top 3. Charlie Chaplin, the Nazis, and John Lennon. These cases are extraordinary. But this case, basically, my father discovered the notion of prosecutorial discretion. Like an iceberg, there were cases out there that we had heard, drugsters and mobsters and bad people that were given some discretion to stay in America. And even though Dad had won the case eventually, John financed it, and they discovered the prosecutorial discretion program that President Obama, 45 years later, relied upon. It's taught now in law schools as the Lennon Doctrine. The president then now saved 1 million people under the DACA program, Deferred Action for Childhood Arrivals, for people who, by the grace of God and acts of their parents, did nothing wrong, but were born and then brought into America. They don't have accents, they don't pledge an allegiance to any other flag, and they are judges, police officers, and everything. And these individuals now, by the grace of this good case, is so important. Needless to say, it's a good read because John Lennon had a conviction of cannabis. When my father asked John if that was marijuana, he quipped, "No, it's better." And my father looked at him again, had no idea who John was or what marijuana use was. He bought his first pair of dungarees in the handling of the case, but he proved, like a very Talmudic scholar, that the statute restricted marijuana, and here there was a conviction for cannabis. And more importantly, it was drugs that was planted, so you didn't have the evil intent, the mens rea. We've used that argument in subsequent decades to help the likes of Joe Cocker and other wonderful artists who were convicted and had issues, and that they needed to have the culpability, the knowledge. A Western society should not castigate somebody for something they didn't have the intent, particularly if it was planted. And eventually, the Bobby who had planted it, Sergeant Pilcher, went to jail and so forth. So the notion that a lawyer could toil in one field and affect the law 45 years later happened in our family and in our firm, and it can happen to you. And I can tell you that you are a dream maker when you embark in a robust career in immigration. And if you only have a chance to talk to me or other lawyers that you develop a trust in over time, you'll see the majesty of what it was that you decided to go to law school in. And I have to tell you that it's an endearing field, and there's so much more room for more people than myself. I'm going to now entertain some questions. Somebody asks about about an R1 visa. Can this also lead to citizenship? So the answer is absolutely. An R1, again, is a visa that's good for 5 years, 2.5 and 2.5 years. After 2 years, and this law does sunset, there is a provision that would allow you to apply for a green card. The form is the I-360, and you want to show 2 years established religious occupational work before you make the application. In fact, to the person asking this question, if the person physically came in to America with 2 years under their belt, you could apply for the green card while they're abroad and get them a green card. Or you can physically apply for the green card right after getting the R1, because you can show uninterrupted 2 years. Be very careful over summer excursions, or if a person takes 6 months off, it has to be consecutive 2 years in order to qualify for the green card. But it's a wonderful path of getting a green card. And if you have, we have a very delicate case now where a child needs cancer treatment, and the mother and the father raised $1.5 million in their home country, and they need to stay here longer. And I basically told one of them they should get a job in a religious institution, and they're going to work there legitimately, and it will give them up to 5 years. And 2 years into it, they can apply for a green card. But the parent dutifully has to work. The other one has to go check on the child, and they're going to get a green card. You can imaginatively use these visas so long as they're poised, they're legitimate, and the religious institution has a growth of its attendees, or a teacher leaves, so that when they knock on the door, again, you're not getting an R1 visa or a green card unless somebody knocks on the door, and it can take a long time, that there's a justification. Would you recommend any organization rate pro bono work for non-immigration attorneys to assist people who suffered under the last administration? Yeah, I would. I would first call the American Immigration Lawyers Association. My dad was head of that in 1970. He's the oldest member of that prestigious pioneering group, and it's still in business. In his day, there were about 400 immigration lawyers, maybe a handful that could afford to employ another lawyer. They're still around, and they're doing beautiful work. They're all over the nation and the world, for that matter. They have European groups and chapters, and they can point you into the right direction and charitable group in your locale. I have also a particular respect for Catholic charities, Hebrew Immigrant Aid Society, Hayas, and the Lawyers Guild, and a lot of other wonderful groups in the tri-state New York area. But find someplace, find law schools that have clinics. I teach generally 2 classes at the Cardozo Law School. One's an externship. Find clinics where students are helping pro bono, and see if you can give some time. It is immeasurably satisfying and resourceful of you. And you'll see, as a mayor, I marry people all the time, and I get Christmas cards for generations. As an immigration lawyer, there are people who have literally named their children after my father and me because of the effect that we had in their case. We got an asylum this afternoon. We didn't take it up today, but this family has become part of our family only because of the connection that we have. A follow-up regarding the R1, is it typical for the visa to be limited to 1 year when the applicant requested more time? No, that's not typical. You're entitled to request up to 2 years. It's likely that the lawyer made a mistake and only requested a year. We see that all the time. You're entitled for 2.5 years on an R1 and another 2.5 year extension. In any event, I take it by the fact that there aren't other questions. I either put you to sleep or you did your CLE requirements. Feel free to reach out to me if I can be of any help. It's michael@wildslaw.com. Again, michael@wildslaw.com. I wish you each Godspeed, safety, and robust careers in our area of law.